So good evening, everyone. You're very welcome here this evening. I am Nora and I'm Director of the Information Law and Policy Centre. So welcome to the Institute for Advanced Legal Studies. For those of you who haven't been here before, for those of you who have, welcome back. I expect a number of you already receive notifications or updates about our events, but if you don't, please sign up to our mailing list or follow us on Twitter. And while I have you all here and have your full attention, I'm going to take this moment to tell you about the next evening seminar we're going to be hosting, which is going to be on the 19th of February here, and which Professor Irene Ning of the University of Warwick is going to be talking about the topic of personal data as an asset and user empowerment. So full details of registration for this event are on the Centre's website and the Institute's. And now for this evening, it is my very great pleasure to introduce our panel here. Our speaker for this evening, over here on the far left, is Damian Clifford. He is a visiting scholar to the Institute and the Information Law and Policy Centre for the next year. He is also a doctoral researcher at the Centre for IT and Intellectual Property Law, at the University of Leuven. He's previously worked in the area of online advertising and enforcement. And he's also been involved in several EU Horizon 2020 projects in law and technology. So for our panel of discussants this evening, we have two very prestigious speakers. In the middle here, we have Dr. Edina Harbinja. Is that right? Okay, I'll just check beforehand. But Dr. Edina Harbinja, who is Senior Lecturer in Law at the University of Hertfordshire. Her principal areas of research and teaching relate to legal issues concerning the internet and emerging technologies. She is also a leading expert in the area of law and policy governing the topic of post-mortem privacy, and her research and publications in this area have been cited by courts and legislators in the US and in Europe. And last but not at all least, we have Haddadi, who is Senior Lecturer and Associate Professor at the Faculty of Engineering at Imperial College London. He's also Deputy Head of Research at the Dyson School of Design of Engineering and an Academic Fellow of the Data Science Institute. His research interests concern user-centered systems, Internet of Things, applied machine learning, data security and privacy, in particular designing and building systems that enable better use of our digital footprint, but while also respecting privacy, which we're all very happy to hear about. So in terms of format for this evening, our speaker Damian will speak for about 30 minutes, and then both of our discussants will follow up for about 10 minutes. In terms of the camera, that will just be recording the presentation and both of the discussants afterwards, but you will not be recording or making publicly available the discussion with you afterwards following the panel's presentations. So finally, I'd like to thank the panel for being here this evening and to thank you for being with us. And I'd like to invite Damian to speak on this evening's slightly amended seminar topic of citizens, consumers in a personalised galaxy, emotion-influenced decision-making, a true path to the dark side.
Thanks, Nora. So I suppose I'll stand to make it easier. So this is actually a forthcoming book chapter, and actually Edina is one of the editors of that book, so this is kind of a peer review process as well for me, which is interesting. But yeah, so this is also, as Nora mentioned, part of my PhD studies. So it's the topic of what I'm going to actually discuss here is a little bit narrower. I'm going to just focus on online emotion detection and its use for advertising and marketing purposes, whereas my PhD itself was taking a little bit of a broader perspective and looking at public display advertising using motion detection technologies as well, so it's a little bit broader. So just to, I suppose, give a taster to begin with, and some of these titles are a little bit funny because they're actually based on the book that I'm writing in, or I wrote this for, is supposed to be a little bit of a geeky book, so so there's a lot of Star Wars references, so apologies in advance. But essentially, what I'm looking at is the emergence of what Andy McStay termed empathic media. So technologies that are sensitive, or emotion sensitive, or they have the ability to detect emotions. So you're thinking about like smart watches and things like that, but also I suppose various techniques that are used in an online setting to be able to detect emotion in real time. Now, this is not really a new phenomenon. In the advertising and marketing sphere, there were, I suppose, more kind of laboratory setting type situations where they put nodes on people's heads to detect emotions. So it's not exactly a new phenomenon, but there is an increased capacity to do this type of emotion detection in real time. And there's a lot of examples. So we can look at the Facebook emotional contagion experiment. So that's where were able to essentially, on the news feeds of Facebook, able to detect emotion and also influence emotion through altering what appears in your news feed. Now there's also a lot of other Facebook examples. So they've added not only the like button, but the reactions feature, which is another kind of emotional response. So there's been some research coming out of Facebook about using that to detect emotions. But there are also like a whole host of other companies that are doing this, and not limited to just like Facebook, other big companies, but also like niche companies as well that are involved in emotion detection. And I suppose just in terms of how they're doing this, so I already mentioned smart devices, and there's also text and data mining, voice analysis, but also through the analysis of facial expressions. So like there are, I suppose, a lot of applications to this, but what I want to look at really today is online emotion detection and how it is used. So currently, and this is, I suppose, taking it from Andy McStay's work as well. He had a report last year on this he got a grant for this to assess, I suppose, emotion detection technologies and their emergence. But he found that currently there's no market for emotion insights. So what I mean is you can't like purchase data revealing emotion insights. No, but he did find a demand for this. However, there are loads of other examples of particular companies actually using this online. So in the entertainment media sphere, you have Spotify and Netflix. So they use it for the recommending of content. So they try to detect emotion in order to recommend. It's listed as being, I suppose, one of the features that they've been looking into. Then from a smartwatches and devices perspective, there's been increasing projects and also companies that are looking into how smartwatches could be used to detect emotion for healthcare purposes or pseudo-healthcare, so well-being, whatever that is supposed to mean. Then there's also companies that are working off assumed emotional states. So that's like using normal online behavioral tracking in order to assume an emotional response. So receptive is that they're a gaming advertiser. So they know when you finish a particular level that you'll be happy. So then they target that state at that particular moment. Now, as I said, emotions have always been used in advertising and marketing. So it's really a question of like what's new and what's the problem with this research or these developments. And this is really, I suppose, it's linked to the broader debate around online behavioural advertising and that emergence. It's essentially like that the increased datification of society, mediated society, I suppose, another thing. What I mean is that your interactions are always mediated by technology. And I suppose in this regard we can refer to behavioural law and economics, certainly, and market manipulation theory. So I'm not sure if any of you would have read this, but for instance, a US scholar called Ryan Callow wrote an interesting piece on market manipulation, so the use of behavioural biases by companies in order to encourage certain reactions, encourage purchasing or certain behaviours. So that was referred to as market manipulation. So on the basis of all that, there has been...
Sorry, can you just repeat the title of Ryan Callow's article?
It's called Market Manipulation. I'm not sure if there's additional stuff in it, but it's...
Digital market manipulation.
Okay, digital market manipulation. There's also an older piece by Hansen and Kaiser. I think they were the ones that came up. They had 3 articles, but if you look at Ryan Callow's paper, you'll find the references to those. So on the basis of that, there's, I suppose, question marks about the enduring relevance of consumer standards, so the average consumer standard, whether someone can be informed and make informed decision making if technologies and companies are using technologies to predict behaviour and then target behaviour on that basis. Now, emotions add a layer of complexity to this, because behavioural law and economics and market manipulation theory really refers to rationality. And there's a question whether emotions are in fact rational. So like the detection of emotion kind of adds another layer of complexity here potentially. And if we, I suppose, the traditional relationship between law and emotion is kind of summed up here by a quote from Maloney. So essentially that they belong to different spheres. So it does add extra question marks here. So just specifically in relation to law and motionist theory, it's not particularly new, but it's still relatively new. And it emerged as a means of challenging legal rationality, essentially. So there are similarities with law and neuroscience and behavioural law and economics, which really challenged this rationality paradigm within the law. So what I mean by rationality paradigm is if you're an informed decision maker, the law, I suppose, relies on your ability to act rationally. That's very consumer protection orientated idea of that, but that's it in a nutshell. Now in the law and emotions theory, I suppose there have been two main groupings. So the ones that I suppose recognize emotions as being part of cognitions, so part of brain activity essentially, or they recognize a cognitive element, and those who don't recognize this cognitive element, that they're almost reactions like physical manifestations. Now, in short, because I don't want to kind of deviate too much from the more legal analysis, the evidence would suggest that the first is correct, that there is always some degree of brain activity. Now, be that subconscious or conscious. But I suppose building on that then, it's a question of whether, how you position emotions within rationality, if there is some level of brain activity. And the theories really would position this as the emotions can have both rational or irrational. They can be both irrational or rational. So despite their cognitive element, there is, I probably best to give an example. So it could be based on a false belief if it's an irrational emotion. So you might have a phobia, for instance. It might not objectively be rational to feel that way, but subjectively you do feel that way, but that would be an irrational emotion. Now, in decision theory, I suppose that's still not giving. There's another band then of theoretical studies about the effect of emotion on rationality, and that will relate to the effect of emotion on decisions themselves, and whether decisions can be rational. So there's, I suppose, a general study by Lerner and her colleagues. So she's a decision theorist from Harvard, and essentially she states that emotions and rationality are inherently linked, or emotions and the ability to make a decision are inherently linked. So then it's about how you categorize this then in a legal sense. So Eric Posner, when he was writing about this, basically said that you can have, if you're in a subjective state, that emotional reaction can be internally consistent. So you're correct to believe that way because you feel that way. So your outcome, your decision is rational given that emotional state. But I suppose given the increasing capacity to detect emotion in real time and then target that, is that how do we kind of equate those two? How do we look at protecting the consumer if they can be targeted on the basis of a detected emotion? So even despite this internal consistency. So if this emotion, even it could be influenced from the outside, if we think of the Facebook emotional contagion experiment. So these are the types of issues that I suppose I'm really looking at and form the basis of this chapter to critique the role of rationality as a paradigm within the law. So from that then we can question, okay, we have data protection and privacy law. So could data protection and privacy law not form a basis of protection? So essentially if you can control the data about you, then you can control its outcome, yeah? So they can't, you can say, okay, I don't want to be, my emotions to be detected and targeted for advertising purposes, provided you control that data. Now, for those of you that don't know, we've had a major reform of data protection that will come into effect in May of this year. So it's the General Data Protection Regulation. Now, there have always been, I suppose, key concerns with the data protection framework. And I suppose the ability of this principle-based approach regulation to respond to the challenges of big data. Now, I suppose we could look at, say, the purpose limitation principle, which essentially says that you have to declare a purpose and it's limited to that purpose. You can only process for that purpose then. But with function creep, etc., and analytics stratification, there has been question marks surrounding the ongoing legitimacy of this, because purposes are often decided ex post, so after gathering of information. Data minimization is another one, because essentially the datification of everything. So there's been an ongoing, I suppose, discussion about the ongoing legitimacy of these principles. Now, it's a bit premature to say that there's no point in even looking at these anymore, but because the GDPR has been essentially, this regulation is revising the old directive. So there are certain key changes. There's a focus on accountability, a risk-based approach, and several other changes with fines that could effectuate more meaningful change and render these principles a lot more effective. But even, okay, we can take then that at least theoretically, data protection should be able to protect, you should be able to control your data to at least some extent. So I suppose is to figure out to what extent actually control is part of the data protection framework, and where does it actually lie within it. So in this context, I suppose it is important to mention where data protection is fundamentally protected. So it's Article 8 of the Charter of Fundamental Rights of the European Union, which essentially provides this fundamental right. Now this is important because it's, I suppose, it's the first time that it was protected as a distinct right in the legal order. So privacy is protected in Article 7, and Article 8 is a delineated distinct right for data protection. So I suppose the question mark then is about whether control can be essentially an essence of this right or an important component of this right. And in this regard, we can look towards the further specifications in Article 8.2 and what is needed for the limitation of a right, which is provided for in Article 52.1 of the Charter. So Article 52.1 essentially states that in order to respect the essence, it has to be laid down by law, so there has to be a secondary legal framework protecting as a protection, and it needs to be proportionate and necessary. So they're the real two criteria: proportionate and necessity, those tests. So then I suppose it's a question of how the GDPR respects these conditions in upon themselves to see if we can actually position control as the essence of the right. So can we control our data about emotions, our motion detection data, essentially, and is this then an effective means for protection? So in a separate article to this one that I wrote with a colleague of mine, we tracked the role of fairness as a system of checks and balances in the GDPR, essentially, and looked at how proportionality and necessity in the Charter are manifested in this regulation, and how they would respect essentially the balancing exercises that are inherent in the Charter in Article 52.1. So basically, if the GDPR as a piece of legislation did not respect Article 52.1, then it would be an illegitimate limitation of a right. So we found that the GDPR protects the right to data protection in particular and rights and freedoms in general. And you can see that in Article 1.2 of the GDPR. And I suppose the thing that would be important is that the essence of the GDPR is different from the essence of the right itself, because the right to the data protection is just one singular right, whereas the GDPR protects many fundamental rights. It rights in general, rights and freedoms in general, and data protection in particular. So even if you still, I mean, it's questionable whether you can position control as the essence of the right, even in upon itself, but control as the essence of the GDPR is a little bit nonsensical because it goes after many fundamental rights and freedoms, although it is a very important component within the protections. So, I mean, we can still say that the GDPR aims to empower citizens, and it does take, I suppose, this informational self-determination. So I would position control broadly, yeah? But essentially, the right and the GDPR are there to counteract power asymmetries. But it's really a question of whether they can effectively give data subjects the ability to restrict the gathering of their personal data and therefore restrict the ability to detect and target emotions. But I suppose then it's a question of whether there are actually more problems in practice when we look at emotion detection itself. So an important consideration here would be what are emotions essentially in a data protection sense. So data protection requires the processing of personal data. Are emotions personal data? Are they the separate category of sensitive personal data which requires added protection? Are they information under Article 5.3 of the Privacy Directive? So that's Article 5.3 protects certain web tracking techniques such as cookies. So there are, I suppose, a series of different data categories that the emotion insights or the data used to detect, to discover emotion insights could fall into. So I suppose just a little bit more on each of these. Now, in an online sense, if you want to use emotion detection in order to target an individual, then you have to know who the individual is. And you have to be able to track their machine in order to then target them. So, I mean, it's very likely that some form of cookie or a cookie-like technology will be used. So then that would require that Article 5.3 of the e-Privacy Directive would be satisfied. So essentially this says that the storing of information or the gaining access of information already stored in the terminal equipment of the user, it essentially requires consent. Now it's a bit of funny language because terminal equipment, it's actually electronic privacy, it's part of a telecoms package. So terminal equipment, they're kind of almost referring to a handset here, but it can extend to laptops and smartphones, etc. So we can see that that definition is a little bit broader than the definition of personal data. So personal data is any information relating to an identified or an identifiable natural person or data subject. So it's not just information, it's information that relates to someone essentially. But again, it would be very difficult to say that emotion detection technologies and emotion insights could not be classified as personal data, given that you want to target an individual. So they have to relate to someone. If you want to target them, you have to find out who they are. And that, related to that personal data category has been construed extremely broadly. So it's essentially the ability to single someone out. Not a name. It could be essentially pseudonymous data is still personal data. But then are emotion insights and the data used to discover them, could they be considered sensitive personal data? So in the definition of what sensitive personal data is, we see that there are certain specific categories that are mentioned. So we've racial or ethnic origin, political opinions, religious, etc. So it's a question of whether they fit into that. And I suppose for our current purposes, it's a question of whether they would be classified as biometric data or health data. So if you go through the definition there, you'll see that they're specifically mentioned. Now, there has been increasing discussion about whether this classification between sensitive personal data and personal data again has ongoing legitimacy because of the analysis-intensive processing. So the lines between them are being increasingly blurred. And we can see this, I suppose, there would be some relatively clear-cut examples of when it'd be sensitive personal data. So if it was using biometric data, but then I suppose it's important to remember that it's biometric data as defined in the regulation. So it's biometric data for use for the purpose of uniquely identifying an individual. So it's not just biometric data as would be defined in scientific terms. Another I suppose the thing that wouldn't be that clear cut would be the text and data mining, as that might reveal sensitive data. So you might only be gathering relatively innocuous information, but when analysed thoroughly, it might reveal sensitive information. And then I suppose you could also look at consumption patterns if you're talking about media consumption. So, I mean, if you're watching or listening to certain programs or music, is it possible for that to reveal something about you that would be categorized as sensitive data? So the boundaries between these two categories are very difficult to define, and they're also often context dependent. So I suppose it can link the sensitive personal data dichotomy, if you will, can be linked really between the means used or even the purpose that is used to achieve that detection of the emotion. So it raises a lot of concerns then when you're thinking about legal certainty for a controller, so the one that is in charge of the processing. But what else does it mean? Because if you think about sensitive personal data, it requires the explicit consent of the data subject. So unless the data are manifestly made public. So manifestly made public would be like if you're on a social media site and you put your sensitive personal information like health data open to the public. But otherwise you need explicit consent. What about like normal personal data? So normal personal data in a business to consumer setting, generally speaking, you would have three available. So you have consent, legitimate interest, and contract. So I suppose then, if you look at what each of these means, I suppose the construction of them, contract and legitimate interest hang on a notion of necessity. So is it necessary for the performance of the contract? Is it necessary for the pursuit of legitimate interest? So then I suppose, what would be necessary? And then given the fact that emotion detection will require intensive profiling, does this actually upset this? And what I'm referring to here specifically, I'm sure some of you will already know this, would be there's a particular provision within the regulation that refers to profiling. So it's Article 22. So Article 22 essentially says that a data subject has a right not to be subject to automated individual decision making, including profiling, concerning him, which produces legal effects or similarly affects him. So obviously there's going to be a lot of debate about what legal effects might be a little bit easier to interpret, what are similarly significant effects. Now there has been some discussion, especially like the Article 29 Working Party has produced an opinion saying that this right is in effect an ex ante right. So it's a right not to be subject rather than an ex post right where you can say I don't want, you can restrict it, you can request not to be. So essentially it's another ex ante provision. So if we look at this, this Article 22, there are essentially three grounds available for that type of profiling, so intensive profiling. So we've contract again, we've authorised by law, which won't really be applicable in this situation, or explicit consent. So we can see again, similar to the sensitive categories of data, we've got explicit consent to our contract. Our contract isn't available for sensitive data, but we've got explicit consent. So essentially then you're kind of going, what's going on? So what's available, yeah? So if the data used to detect emotion or personal data, then you've got consent, contract, or legitimate interest, potentially, depending on what is deemed necessary in the given circumstances. If cookies are used, you've got consent, unless they're functional cookies. So that could be for the provision of the service. if it's sensitive personal data, then it appears that it's only explicit consent is available. Then if it's Article 22, it's explicit consent or contract. And this really raises the question then about what is necessary. So that's an important question to answer. So it's what's necessary for the performance of contract in particular, because it's probably the most likely alternative, given the fact that it features most in comparison to consent is everywhere. But so from the various opinions, or the old opinions on the directive, it's very unlikely that necessary for the performance of a contract will satisfy in this particular circumstance, because it's very much linked to purpose. So the purpose of the contract, is it necessary for the achievement of a purpose? So if we think about a healthcare sector, or healthcare application of motion detection, then we can say you purchase a smartwatch and you purchase an app on that smartwatch which allows for motion detection for healthcare purposes, like your mental health tracking. Then you could say that the processing is necessary for the provision of that contract. But in an advertising marketing sphere, it's very difficult to say that it would be necessary. Now, I don't know how I am doing on time, but...
Fine.
Okay, yeah. Now, this is important because the GDPR essentially strengthens consent, and it strengthens consent in a very robust way in comparison to the directive. And there has been a lot of discussion, I suppose, about the effects of this. So, in particular, there's a specific provision added in Article 7 that outlines the conditions for consent. And essentially, it's aiming to fill in these gaps in the rational, autonomous agent fallacy that was there before. So essentially the fact that data subjects were unable to really make informed decisions due to information overload, long legalese and privacy policies, etc., and just the sheer number of notifications that they have to accept. And there's also, I suppose I just briefly mentioned, because it's something that I look at as well, is the overlap between consumer protection and data protection law. So there's a specific reference to the Unfair Terms Directive in Recital 42 in relation to pre-formulated declaration of consent. So that's really, I suppose, something that's a little bit up in the air still, but there are definitely the consent has been strengthened, or they've aimed to strengthen consent in the GDPR. So, as I said, it doesn't look likely that contract could be used, or legitimate interest could be used in specific contexts of motion detection for advertising or marketing purposes. But there is another element to look at, because we have two legislative developments which are kind of threatening the interpretation of Article 7 and Article 7.4 of the GDPR specifically. So, although it might not be necessary, can you make access to the service conditional upon consent? So we can see that Article 4.11 defines consent as any freely given, specific, informed and unambiguous indication of the data subject wishes. So really, I suppose this is a threat to the freely given stipulation. So, I mean, if you're saying that you have to consent in order to access the service, can you say that consent is really freely given? And specifically important here is Article 7.4 GDPR. So, where it says that when assessing whether consent is freely given, utmost account should be taken of whether the performance of the contract, including the provision of service, is conditional upon consent. And that's not necessary for the performance of the contract is linked to what would be contract. So it's trying to delineate between contract as a grounds and consent as grounds. And basically saying that if access to the service is conditional consent, then it has an impact on the freely given stipulation. Now, I suppose emphasis here is on the utmost account. I mean, what does that mean essentially? In the recitals, the legislator is a little bit more definite about this when they say that there's a presumption that consent isn't freely given. But I suppose, realistically speaking, if you're talking about Facebook or any large social media company, or even Google and Google services, how could they ever respect that? Essentially, is that essentially undermining their business model? So there is kind of question marks. I mean, do any of us actually have an option to say to opt out of this? Such a large provider given the asymmetries. So there are question marks about this. So the legislative changes then, or legislative challenges this, and the interpretation of what Article 7.4 might mean, are kind of manifesting themselves in two current proposals. So we've got the proposed e-privacy regulation, and we've got the proposed directive of contracts by digital content. Now I'll just briefly say how they're challenging. So from an e-privacy standpoint, there is a question mark, so that it would be the reform of the Article 5.3 that I was mentioning before, so the cookies provision. And there is a question mark about whether it's questioning the legitimacy of tracking walls or cookie walls. So essentially, like if you're blocking cookies, you would get a banner saying accept cookies or leave the website. So you essentially have to accept if you want to view the content. So it's really in the interpretation of this 7.4. They would, if they don't specifically ban this, then they're basically saying the interpretation of 7.4 is that you can render access to the service condition. Now there have been criticisms of this, and it's an ongoing debate, but I just want to highlight it as an issue. The other one would be the proposed digital content directive. Now this is kind of an interesting one that has escaped, I suppose, large-scale discussion in a data protection sense from the data protection community, but it's very important. So Article 3.1 of the Commission proposal recognises the concept of counter-performance. So essentially positioning data, including personal data, as counter-performance. So essentially then you're saying that personal data is a de facto payment. So you can say that the surrender of that data is, again, you can put it as conditional for the accessing the service then, because it's a payment. Now there are ongoing discussions with this again. So we have a Parliament version which kind of removes the notion of counter-performance, and same with the Council proposal, but they still are basically recognising that under the condition that personal data is provided. So it's kind of, how does this relate to the freely given stipulation and the requirements in Article 7.4 of the GDPR? So we're going to have to wait and see. I have some questions there about that, but I think in the interest of time, I think I'll tie it up. But essentially, the point I suppose I want to make is that from a data protection sense, it's very unclear whether the GDPR will really be able to cope with these technologies and the emergence of these technologies. And I suppose a real difficulty here is that everything is focused on the upstream. So the data gathering and processing aspects rather than the downstream effects, so the personalisation effects. So the question then is, how do we ensure the ongoing viability of the average consumer standard? And how we can actually create an environment in which consumers can make a rational choice, or when they're essentially know when they're deviating from rationality. How can we protect them given the emergence of this technology? And I suppose just as a couple of ideas and things that I address in the paper would be that can we use existing consumer protection mechanisms in order to do this? So I'm looking towards the Unfair Commercial Practices Directive, which is essentially a cradle-to-grave consumer protection mechanism, and there's a question mark about whether it could be used to mitigate the effects of personalisation. Now there's specific layers of unfair commercial practices in there, and it relies again on an average consumer standard, but it's a question mark of whether it could be adopted and changed in this particular setting. I suppose just to point to it then, there's very, I suppose, mixed messages coming out of the Commission on this, because they had a guidance document on the interpretation of the Unfair Commercial Practices Directive, I think it was about a year or 2 years ago, and they said that essentially in certain circumstances personalised pricing or marketing could be combined with unfair commercial practices in breach of the Unfair Commercial Practices Directive. So it's kind of unusual, I mean, if it's combined with an unfair commercial practice, then it was an unfair commercial practice to begin with, so why mention personalisation? So I think that there's a willingness to go this go down that route where personalisation could be an unfair commercial practice, but they're kind of humming and hanging over it, essentially. So then I suppose it's whether we should look beyond information requirements, whether we need paternalistic interventions for the application of these technologies. Essentially, like if individuals are being emotionally manipulated, then how do we actually return them to their subjective state where they can make a decision? Do we need to blacklist certain practices in that B2C sphere? Now, I'm conscious of time, so I think I'll just leave it at that. There is a question mark about how this could actually link to, because if you're going to blacklist certain things, then you're actually attacking the person's autonomy in itself. So there's also whether regulation itself is an attack on autonomy. But I'll leave that, and I'll leave the panelists then discuss what I said. Okay, thank you.
Damian, thank you very much for a really detailed and very wide-ranging analysis of emotion surveillance, emotion monitoring, as I know I've been paraphrasing it as. And also, I think it was very useful to also walk through not just the relevant data protection legislative provisions, but the other relevant laws that can also be applied to this area. When you talked about unfair consumer practices, and also talking as well about the privacy content directive as well. And of course the e-privacy directive, which is currently being revised as well at the EU institutional level. There are a lot of developments in this area that is going to feed into the governance of emotion surveillance in future. So it could not get more cutting edge than this, everyone. I cannot stress that enough. But before I say any more, I would like to hand over to our discussants. Edina will speak first, and then Hamid will take the floor after. Whatever you feel more comfortable with.
It's fine if I said, because I don't have slides, and I've got some notes in my Word document on my phone, so I can't remember all of the points that I wanted to raise. So thanks, Damian, again, for this amazing paper that I read a couple of months ago already, and now again to prepare for the talk. And as Damian said, I'm one of the editors of a book in the book series called Future Law with Professor Leuven and Professor Burkhard Schäfer with the Edinburgh University Press. And the first book is a collection of chapters that will hopefully come out in October, so I'm now taking space a bit for shameless promotion. And we'll be talking about emotions, Star Wars, immortality, Disney princesses and data protection, and many, many other geeky, sci-fi, as well as popular culture topics and the law. So,
I think promotion of Star Wars is very welcome here.
So, Nora stole actually my first point about the significance, apart obviously from the book, that's very significant, so we loved having this chapter there, is that this talk and this chapter, this paper available now on SSRN already, so you can read it, and it's quite long, 30 pages. So the most, for me, very, very important, one of the most significant contributions is bringing and covering all of these different areas of law that sometimes, often in data protection and privacy, we disregard because we focus on only data protection, GDPR, or only e-privacy directive regulation, or we sometimes compare them, and obviously human rights as an umbrella area of law. But Damian brings in unfair commercial practice, consumer protection law, contract law, although we can discuss that, the differences between different contract law and consumer protection as a harmonized area of law at the EU level, but then also digital content and telecoms, and he's making really useful parallels in this paper. And for me, I learned a lot when I read the paper, and I teach telecoms law and the data protection at my university as well as contract law. So I struggled to make all of these parallels as well. So thank you, Damian, for doing this. My first, and I think the overarching theme that I saw as a lawyer in this paper was the reasonable or rational person test that we in the courts use across the world. And so how do we see this person in changing society with information asymmetry, with unprivileged groups, women, poor that different ethnic backgrounds, including mine. So how do we cope with this? There is some reference in Damian's paper on the European case law and the benchmark that takes, in addition to reasonable, well-informed and reasonably observant and circumspect person, there are factors in certain cases that have been taken into account, such as social, cultural, and linguistic factors, in addition to that objective. So I would argue it's an objective test with some subjective elements as well. So if we bring in this emotional test or emotions into play here, so my question for Damian, I guess, would be, so how would we redefine the test then in these cases, in this area of law, or the specific stream of cases? Is this a particular group of different emotional types? So are these different emotional types as defined by psychologists, social scientists, whoever? So am I, as a woman, more reasonable, sort of reasonable woman, different from more emotional women and different other types, or whatever tests that we could use? So would that be helpful? So to have something that in law matches segmentation that we have in machines, and how machines divide us already and what inferences they make about us. So as law, are we behind with these objective, reasonable, centuries-old tests? So that's my first question. Probably might not make sense for black letter lawyers, but I think it's important. The second one again. The second question for Damian, and then the third point is again quite abstract and general theme about citizens and consumers. So who are we in this context? Are we citizens? Are we consumers? And we see here overlap of public and private law and elements of data protection, human rights, constitutional law, as well as contract law, and us as autonomous beings and someone protected by those public law elements. So how does Damian understand those, this interplay and these concepts in this specific area of emotion detection and profiling? He does have a useful discussion in the paper about data subject participation, its limits, quoting Mantelero and Coops and other important scholars in the area. But I just wonder how would he see, because it's not very clear in the paper, in my opinion. One of the comments to the paper. In terms of emotions and personal data, or emotion data about emotions as personal data, sensitive personal data, in addition to health data, I could see perhaps maybe data regarding sexual life or sexual orientation as well. If we analyze emotional data on Facebook or social networks, we can infer a lot about someone's sexual life and orientation. Well, mine definitely. If you analyze my profile, that is sort of protected by quite a lot of information about that. So I'm not quite sure whether personal data here. I'm not convinced that we could always see that data as personal data. And again, you were trying to establish this connection, but this is something that is quite interesting, I think, and we'll need probably a bit more research here. With regards to Article 22 and profiling and not to be subjected to automated decision making, what these significant effects, or that something that significantly affect the data subject, can that be related to their emotional reactions and significantly affect their emotions and their behavior by profiling and emotion detection? So could we make, this is now stretching it really, really far, I know, but could we see some value in that? Okay, there is, again, I don't think you mentioned this concept in your talk, or I overheard when I was on Twitter tweeting about your talk, libertarian paternalism, and as one of the solutions, or one of the concepts that you see that could be useful for this area. And looking at that concept plus behavioral economics and some of the literature you drew from, I would ask whether this is really applicable for Europe and our philosophical and ideological approaches to import some of these American concepts. I'm sure it will be much easier after Brexit here, but for the rest of Europe. So how does Damian see the application of these very interesting theoretical approaches to the European soil? So I think I would stop here, probably for 10 minutes. I think I've opened some questions for Damian, and I'd like to hear his response, and obviously maybe some questions in your heads that I would also like to hear. Questions for you. Thank you.
Thank you very much, Edina. Damian, are you happy for Hamid to also give feedback and then to answer together, or?
Yeah, I mean, I don't mind. I've taken down the question, so I think I can go ahead.
Okay.
Totally engaged.
Perfect. Right, Hamid?
Thanks. As one of the geeks in the room, at least I can recognize Leuven there as well. So I thought I'll just mention a bunch of technologies that there's out there and what the implications the regulation will have on the technology and vice versa. Because as in the last 20 years that we've gone from the traditional model of billboard advertising and the whole influence theories, from the two-step flow of information to accidental influentials, to now the internet that allows us to really go and do extreme personalization of content, we need to really think about how's the interplay between this data collection, the legal implications, and the new regulations like GDPR is going to play against each other. As obviously one of the whole purposes of the internet is actually showing ads in addition to cat videos. Unfortunately, like what's currently driving the internet economy is the advertising revenue. It might change in 10 years' time, but today that's the model. You don't pay for anything because they get access to the sensors on your phone, and that sensor on your phone can tell whether you are, for example, bored because you keep tapping on the screen, and even if you have not given the list of apps on the phone, just by the fact that at 12 midnight you're repetitively tapping on the screen and you're switching between apps, it's showing a signal, right, that this person is, for example, bored at this time of the day, or what kind of sleep patterns you have, what kind of apps you've installed on your phone, basic things like that. And also the other thing, which is, at least from my point of view, not very clear with this discussion, is that if access to my accelerometer and pedometer and heart rate monitor and whatever, I've given access to a bunch of sensors to a third party, and I've consented to it. I've installed the app, I wanted to do this heart rate monitoring thing and find out if I'm doing the 10,000 steps a day or not, whatever that even means. Whether the inferences that are then taken out by the second party and the third party and the fourth party and so on and so forth are counted as my personal data or as inferences which are then made on my data by somebody else. And because this is a complicated space, we only see, I mean, we keep talking about Facebook and Google and stuff. These are actually the good guys. These are the guys that we know them, we know where they are, we know where their offices are. We can go and query them and get our data. One step further away from these guys, there are thousands of companies there trading data, trading machine learning models, algorithms. And this is not so much about necessarily showing the hair transplant app to Hamad Haddadi because we did an image recognition and he seems to be able to do well with some hair transplant. Only because trying to find out that, okay, the guys who live in West London are between this age and they don't have much hair, what time of day should we show what type of hair transplant advert to them? So it's not so much at the moment about the really personalized adverts to a single individual. Also because and I have a lot of friends in the advertising industry, specifically in Facebook and Google types. Also, they are a little bit hesitant of dealing with this personal data and the sort of inferences that can be made from them. So sometimes even the data that comes to them and some of the keyboards, they are sensitive and they're hesitant of even having those data. So they are keen, for example, on being able to do machine learning and inferences on unencrypted data, for example. So you cannot really infer everything, for example, sensitive data, let's say. So I think it's worth thinking about the consequences of these regulations and how it interplays with the consent process and the data collection process as well. Because actually, even the people who are doing a lot of this work, they don't know why this specific machine learning algorithm, when you give it access to the data from these 10 data streams and these 10 sources, it says that this advert is best served to this population at this time of the day. It's actually not explainable, but yeah, whether it's a good thing or a bad thing, that's where we need regulations for that. And that's it. I just want to highlight what challenges there are in the technology sector when dealing with this.
Perfect. That was incredibly succinct, Cameron. Thank you. Damian, it would be great to get a response to the questions and issues raised by Edina and Hamid, and then we can open up to the floor for other questions.
Yeah, so I'll just try and deal with them in order. So, Edina, your first question was about the rational person test. So how do we redefine the test in this area of law? Is there a particular group that would deserve protection, or how do we delineate groups? I suppose it wasn't mentioned there because I didn't really have a lot of time, but there are two consumer categories as well, and that's important to mention. We have an average consumer test, but we also have a vulnerable consumer test in the Unfair Commercial Practices Directive. And there's a bit of fluidity between them. So the vulnerable consumer test, it can be it's a specific group that's targeted on the basis of a specific weakness. So I think that there is flexibility in that sense. But something that I would like to highlight, I suppose, is that there's a difference between a data subject and a consumer, because in data protection law there are heightened responsibilities for data controllers vis-a-vis the data subject, whereas consumer law is very much linked to that informed the ability of a consumer to act on their own, essentially. Once they're provided with transparent information, then they can act. So I think that there's an alignment discussion there that's very interesting between the two different policy agendas. So how to effectively cater for this citizen consumer, because it's a bit of a hybrid between them. So I think that that's an interesting question. And it's like, I mean, obviously I didn't mention it as well, but there is potential for, discrimination law, anti-discrimination principles to come in here. But I suppose with emotion insights, a lot of this will be on the basis of differentiation rather than discrimination per se, because discrimination is very much linked to very specific grounds, so like race or sexual orientation, etc. So, but I think it is a much broader. There's a lot of work to be done there, I think, trying to align those. So I think that kind of covered a little bit your second question as well, between the overlap between consumer protection and data protection in public and private law. I mean, the public and private law thing is also interesting. I mean, there have been, I suppose, discussions about the role of consumer protection vis-a-vis the protection of fundamental rights going back for some time. So whether consumer protection is essentially the manifestation of the protection of fundamental rights in the consumer setting. And I think that that's an interesting theoretical argument. I think it's becoming increasingly prevalent given the fact that we're dealing with huge companies, like a massive asymmetry in power. So they're becoming increasingly like public entities or de facto public entities in defining the protection of fundamental rights in that setting. So I think that there's a massive question around that, and it has a lot to do with the horizontality of rights. Now, I would still be defending a vertical nature, I suppose, especially within the European legal order, and I think that the GDPR is essentially a manifestation at a horizontal level of that vertical relationship. So I'm not sure if that's a particular answer, but it's at least probably a nuancing on what I was saying. Then I suppose, okay, so Article 22. So can significant effects, can it be the emotional reaction? So as I described, for Article 22 to apply, it needs to have legal effects or similarly significant effects on the data subject in order for them to have this right not to be subject to an automated individual decision. I think reference can be made again to the recent Article 22 Working Party opinion, Article 29 Working Party opinion, on the scope of Article 22 and its meaning, where they said that particularly manipulative forms of online behavioural advertising would be counted as, could come in within the scope of significantly affects requiring explicit consent. Now, to be honest, I think it's a little bit like, it's very difficult to know. It will depend on the technique, but and I'm probably just reflecting my own feelings on this. But I think that emotional manipulation could certainly it could feature there, but it would essentially require some sort of, higher power saying that. It's very much up in the air, so it's debatable. And then in terms of libertarian paternalism as one of the solutions, that was actually, I think, my second last slide, but I didn't get to it. But essentially, I think that there's something that we can learn from that. So libertarian paternalism is essentially, it's also referred to as nudging. So you use people's mental heuristics to encourage them to act the right way. So instead of market manipulation theory, we use nudging to get them to make decisions that are good for them. Now, I think that there's certainly debate whether this would actually be feasible in an emotion manipulation context, because emotions aren't necessarily rational. So how do you retrospectively get someone to change their opinion on the basis of an emotion manipulation? So there may be some debates as to the effectiveness of nudging in the emotion personalisation sphere. And then I suppose about the adaptability of those techniques to the EU context. I know you mentioned that it might be easier in the UK after Brexit, and I think it's already, as far as I know, there's already a behavioural science unit here for some years. So I think certainly, I don't know, I think there's definitely a potential use of these technologies, or these techniques rather, technologies. And it's, I think it will depend on how things are perceived. It's hard to say how their uptake yet. But I suppose, yeah. And then in relation to some of the points that Hamid was raising, I think, I think a lot of the points were kind of very much in line with the general critiques of data protection over the last number of years, in that we have a problem with what is known as the purpose limitation principle. So the failure to respect the fact that you have to declare a purpose prior to processing and stick with that purpose, and it has to be narrowly defined. That is a problem with the framework, or has been a problem with the framework. It'll be interesting to see with the reform that's brought in by the GDPR, whether the increased focus on a risk-based approach, the heightened role for fairness that I have argued is there in a separate paper, and also things like the fine. So there's an increased capacity to fine, which is a major thing. I think that there's also the introduction of an accountability principle, more specifically in the GDPR. So I think that all these things we'll have to wait and see how it pans out. I think another interesting thing to note is that there's also a research exemption that often gets overlooked in these discussions. And that's very much linked to the interpretation of how the purpose limitation principle will operate as well, because it will come down to national implementations of this research exemption within this regulation, but research purposes are deemed compatible with the first purpose, and that includes both public and private research. So there will be a complex debate, I think, about what fits into alpha testing or beta testing, and what is essentially just preparation for market. So I think that that's really where a lot of that debate is going to go. So I think I'll limit it to that.
Fantastic, thank you.